Hello, everybody. In my seventh lecture series, sixth lecture series, I mentioned about the importance of agency in the contract law. So I'll continue with the contract law series. Today, I'll be delivering a session on the contract law, and it will be my seventh part. It's part seven, and it will be my 23rd lecture series. And earlier I have discussed about the contract law from part 1 to part 6. So this is part 7 contract law 23rd legal series lecture series, and where I have mentioned that the agency is actually, I have mentioned in my earlier in my previous lecture series that agency is a kind of the relationship where it exists between principal and agent, and the process of conducting concluding a contract through an agent also involves twofold relationship. On the one hand, the law of agency is concerned with the external businesses relations of an economic unit, whereas within the powers of the various representative to affect the legal position of the principal. Now, on the other hand, it rules the internal relationship between the principal and the agent, as well as the thereby imposing certain duties on the representative. For example, it can be on the representative, like it can be diligence, it can be accounting, it can be good faith, it can be honesty, it can be integrity, etc. So under section 201 to 210, an agency may come to an end by variety of ways, which states that by principal revoking the agency. It means that however the principal cannot revoke the agency coupled with the interest to the prejudice of such interest. So such agency is coupled with the interest means the agency is coupled with the interest which is being involved in the business. An agency is coupled with the interest when the agent himself has an interest in the subject matter of the agency. That is when the goods are concerned by upcountry constituent to a commission agent for sale, with the poor to recoup them from the sale proceeds, the advances which are actually made by him to the principal against the security of the goods. In such cases, the principal cannot revoke the agent's authority till the goods are actually sold. So, if there is an agreement of such like that, the principal cannot revoke the agency relationship until the agent does not sell the products, and not is the agency terminated by death or insanity. So by that was the first point. Second point is that by the agent renouncing its business of agency, for example, is voluntarily giving up the business of agency. Number third is that by business of agency being completed, if the principal and the agent relationship has been established and the business has been concluded or the contract has been concluded, then the agency will come to an end. And by the principal being adjunct insolvent or the bankrupt in nature, section 201 of the Indian Contract Act. The principal cannot revoke the agent's authority after it has been partly exercised so as to bind the principal, section 204, though he can always do so before such authority has so exercised, section 203. Further, as per to the section 205, if the agency is for a fixed period, the principal cannot terminate the agency before the expired except for the sufficient cause. So if he does, he is liable to compensate the agent for the loss caused to them by thereby. The same rule applies when the agent renounces an agency and for a fixed period, and neither these contingency want to skill the continuous declaration of disobedience of the lawful orders and the rule, but it also insults the behavior which has been held for sufficient cause for disposal of an agent. Now, further reasonable price, the notice has to be given by one party to the other. However, the damages resulting from the want of such notice will have to be paid. So, as per section 207, the convocation or renunciation of an agency may be made expressly by implied by conduct. The termination does not take effect as regard to the agent, and it becomes known to him and to regard his third party until the termination is known to them. So sub-agent is appointed by an agent who actually participate on behalf of the work. When an agent's authority is terminated, it operates as a termination of the sub-agent also. Now, what is an enforcement of contracts? Enforcement of contracts is something that is legal system can be slow and litigious, and India is ranked 163rd out of the total 191 countries which has surveyed the World Bank in terms of easing the enforcing a contract. So we have learned many areas like the concept of agency and what the agency is involved, the offer and acceptance, the indemnity, the guarantee. Okay, and the very important thing is that what are the breach in case of the breach of contract in case of Indian Contract Act. Now, actually, a breach of contract under the Indian Contract Act 1872 occurs when a party fails to perform his agreed obligation, his or her agreed obligation, either entirely or partially, or by way by a defective or delayed performance. It might be a defective, it might be a delayed performance, evaluating the agreed party to compensate for the loss. Now, key remedies which include monetary damages, section 73 to 75, and specific performance and contract cancellation. So there are actually types of breach of contract. Number one is the actual breach, and number two is the anticipatory breach. Now, actual breach means that the failure to perform the contractual obligation on the due date during the performance. And anticipatory breach is that a party declares the intention not to perform before the performance is due, allowing the party to rescind the contract immediately. Section 39. And very important to also understand that is what are the legal consequences and the remedies which are available from section 73 to 75. Now, 73 actually talks about the damages or the compensation for the losses which naturally arises in the usual course of things of business. Special damages are actually recoverable by both the parties knew about the likely loss when they made the contract. And what is a liquidated damage? Liquidated damage is something if a contract specifies a penalty, the court may award reasonable compensation not exceeding the amount named. Specific performance, it's a court order forcing the party to perform the promise. Governed by specific Relief Act 1963. Rescission is the termination of the contract where freeing the injured party from further obligations. The key principles which are actually involved in the breach of contract is the mitigation. Another one is the remedies. Mitigation means the agreed party must take reasonable steps to minimize the loss which has been caused by the breach of contract. Another one is the remedies. The aim to place the agreed party in the same financial position as if the contract had been performed. So there are many areas also I have discussed, like the breach of contract and how the breach of contract can be through the mitigation or through remedial the measures. What are the specific performance and the rescission? What are the concept of understanding the actual breach and the anticipatory breach? So there are many areas where Indian Contract Act 1872 gives us a guidance, a map, a foresight that how the agreement and the contract will come into force with an individual or an entity. So I would like to request each one of you to go through the Indian Contract Act 1872 very properly and to understand and interpret the each and everything, because it is also given in a very lucid and a simple language in the Bare Act. You can refer to any textbook which is available in the market so that you will be able to understand the basic fundamentals behind entering into any kind of contract. So this is my concluding part. I've ended with this contract law series. Thank you very much for watching.